Welcome, everybody. My name is Dr. Phillip Paiement. I'm an associate professor in jurisprudence at Tilburg University. I'm here with my colleague, Dr. Laura Burgers. Laura, would you like to introduce yourself?
Hello, my name is indeed Laura. I work as an assistant professor at the private law department of the University of Amsterdam.
Thank you. And we are here today to discuss with you the climate obligations of the private sector. In today's class, in today's lecture, we're going to discuss the different challenges that arise when trying to identify specific forms of legal accountability for the various forms of harm that are associated with climate change and our changing climatic conditions. After identifying some of the facets of climate change that make it difficult for establishing legal forms of accountability, we're going to look at some of the recent success cases against state actors, against public authorities in climate litigation. But then the majority of the focus in today's lecture is going to be focused on private sector actors. And to do that, we're going to look at four different cases, three of which are ongoing, one of which was just recently resolved, against private sector actors, against oil and gas companies and energy companies. And look at the different strategies, the doctrine that's being used, the arguments that are being applied by climate activists to try to establish binding forms of legal accountability for these private sector actors. So that's an outline of what we're going to discuss here today.
Yeah, so let's start with why it is so difficult, or why it seemed in any event very difficult to establish legal accountability for climate change. And then we mean legal accountability for climate change in general, both for states and for private actors. So one of the issues, of course, with climate change is, first of all, it's an enormous problem that is threatening us in an existential way, because it can really lead to all the well-known results: sea level rise, huge hurricanes, heat waves that can all have deadly results. And still, although there is since 1992 the United Framework Convention on Climate Change, in which all states in the world agreed that they needed to take action on climate change, it's very difficult to do so. Measures against climate change are generally not so popular. So it is, and then in addition to that, it's very difficult to pinpoint who is actually responsible. And one of the reasons for that is that climate change has a very diffuse and in a way extraterritorial nature. It doesn't matter where on the earth emissions are coming from. They will have a global result on the climate. And that makes it difficult in terms of jurisdictions to say, okay, who is actually responsible? Another issue that is a bit related to this is that there is also an intertemporal difficulty, if you like. The warming that we experience today, the Earth is now warmed somewhat like 1 degree, is the result of emissions from the 70s and 80s. Now, and although there is, and that's the third bullet point on the slide there, although there is an international treaty, the United Framework Convention Against Climate Change, and its follow-up documents, including the Paris Agreement, there is an international consensus that states should do something about it. There is not an international framework with mandatory binding reduction obligations. So the Paris Agreement leaves it up to the states to determine how much they actually want to reduce and how they will do that. Another problem, perhaps indeed, which is very similar to what I've already been saying, is that we are all to some extent emitters. By buying products that, we also contribute to emissions taking place. And then specifically with regards to legal accountability for the private sector, so when we do not speak about legal obligations of public authorities, but rather of private actors, and then specifically of oil and gas corporations, there is often this excuse used, but we are working with authorizations. It's not, in a way, as Phillip said earlier today to me, the Wild West. No, there is it's a highly regulated area. So whether this is actually an excuse to escape from legal accountability, we will see later when we will discuss 4 interesting cases against oil companies.
So as we continue to kind of set the stage for climate litigation against private actors, it's maybe first important to consider and take stock of what some of the success stories or gains have been in climate litigation against public authorities. Some of the early cases, and by early cases, we don't have to look very far back, but just in the last 5 to 6 years, we've begun to see a number of success stories come out of climate litigation against public actors. But many of those early cases focus on fundamental and or human rights obligations held by states with respect to their citizens and residents in their territories. The Lagahari case from Pakistan, for instance, found that the Pakistani states delay in taking sufficient climate mitigation activities or climate mitigation measures, I should say, as a public regulatory authority, posed serious risks to fundamental rights violations in Pakistan, and led the courts to establishing a climate change commission to essentially speed up the steps to take action as a national government. And the court retained a role in overseeing that would indeed take place in a quicker fashion. A little bit more recently here in the Netherlands, where Laura and I are based, but also in the neighboring country of Belgium, we see 2 very similar cases. The Urgenda case, which is now quite famous, not only in climate change litigation scholarship and research, but more broadly in environmental litigation, strategic litigation. In the Urgenda and Klimaatzaak in Belgium, these 2 cases are both premised on very similar open norm provisions in their country's respective tort law systems, where the public authorities are being found of having committed a tort by failing to take more urgent climate mitigation, climate reduction, emissions reduction measures, essentially. And what we see that's interesting in those cases is that the plaintiffs in these cases have filled in this open norm of, well, what is the duty of care threshold that public authorities must fulfill. They fill that in using fundamental and human rights norms, as well as the 2015 Paris Agreement reduction commitments made by the Netherlands and Belgium via their position within the European Union. Even more recently, just in this past year, the Neubauer case from Germany is another example of climate activists, in this case, youth representing younger and future generations, drawing on fundamental rights, in this case, the principle of human dignity and the right to life from Articles 1 and 2 of the German Constitution, as well as a future generations clause from the German federal constitution, arguing that the German federal states, the climate law of the German federal state, in its placing greater reduction measures in the future rather than in the near term, that they are disproportionately burdening future generations with the both the duties to reduce emissions, but also the consequences that come with having to reduce emissions in the future. And the courts ruled in their favor, striking down portions of that federal climate law and requiring the German federal legislator to take more immediate and extensive emissions reductions measures. Another achievement that climate litigation against public authorities has achieved is, in some sense, operationalizing the commitments made under the Paris Agreement. So although those commitments are not binding in and of themselves, they're aspirational, you might say, but the Paris Agreement lacks a kind of mechanism to hold states accountable for their target reductions. What we start to see is the use of those commitments in national litigation of public authorities to also make those transform those into binding mandatory reduction measures. So we saw that in the Urgenda case in the Klimaatzaak, but also in an administrative dispute in the Friends of the Irish Environment, which ruled in favor of the plaintiff, the climate activist in that case, at the Supreme Court level. Despite these success stories, however, we increasingly see litigation being taken against private actors, which is really the subject of the lecture here today. And one of the reasons that private actors, the oil and gas and energy sectors in particular, have become popular targets of climate litigation is because there are only so many things which can be achieved litigating against national public authorities. One way to state it is that we have a challenge when we litigate against national public authorities, and that is that their footprints are fairly limited, right? The footprint of or the scope of responsibility of the Dutch state in reducing emissions when seen in a global at a global scale is really quite small. So even these achievements against the Dutch public authorities, the German public authorities, are quite small in their impact. And instead, the carbon footprints of these states is dramatically overshadowed by the very powerful and influential position of multinational energy companies. And so with that in mind, with that challenge of, well, how can we, or how can climate activists target and try to establish forms of legal accountability specifically from those private sector actors who have the most influential carbon footprints when considering the entirety of their supply chain. That ends up being kind of the key focus in our lecture today, but also one of the primary questions that hangs over the head of climate litigation actions to determine whether this is a feasible way of achieving climate action. So with that challenge in the background, we're going to segue now into 4 different cases against private sector actors.
Yes, and the first case that we would like to discuss is the only case that we discussed today where there is already a judgment made by a court, and that is the case of Milieudefensie, which is the Dutch, the Dutch Office of Friends of the Earth against Royal Dutch Shell, a very large oil corporation. And this is a case that was litigated in the Netherlands, and it was actually decided at the 26th of May this year, 2021. And what the claimants argue is that Shell commits a tort that is defined in Article 6, 162 of the Dutch Civil Code by not doing enough against climate change, that is to say, by not reducing enough of its emissions. And it's interesting to see that this article in the Dutch Civil Code defines a tort in 3 possible ways. It can be defined as a violation of a subjective right. It can be conduct or negligence contrary to a legal duty, or conduct or negligence contrary to what, according to unwritten law, is deemed societally fit behavior. And the latter of the 3 is the legal basis of the claim against Shell, and also of the judgment that was indeed decided unfavorably to Shell. And as you can see, this is a very open norm. It's not very clear what is meant by that from the outset. So the court has to interpret this norm. And the claimants in this case had tried to interpret this norm by resorting to a special private law doctrine that was also used in this Urgenda case that Philip just mentioned, which is called the doctrine of hazardous negligence. But the court in the end actually did not go for that interpretation of this open norm, but rather used all relevant circumstances of the case to fill in this open norm, which were in total 14 elements, including, very interestingly, human rights obligations, climate science, and international climate politics. So what the court said in a nutshell was that according to international consensus, whereas states have the obligation to respect, Philip, help me, protect and fulfill, respect, protect and fulfill human rights. And so they not only have a negative obligations not to violate people's human rights, but they also have positive obligations to actually fulfill them. It is a global consensus that companies only have the obligations to respect human rights. So to refrain from behavior that can violate human rights. And of course, in Dutch law, in Dutch case law, the Urgenda case that was litigated all up to the Supreme Court. So it is really like the highest judicial instance in the Netherlands. And there, in that case, it was already established, like Phillip said, that climate change can actually lead to human rights violations. And this might seem far-fetched at first sight, but when you think of it somewhat longer, it actually does make quite some sense. With sea level rise, eventually the very low-lying Netherlands might actually be destroyed at some point. And also with every heat wave, actually elderly people die, so that the rights to life and the rights to private life, home and correspondence is actually protected, or actually can be violated due to climate change events. That actually is not so unsensible. So since corporations have the obligation to respect human rights, Shell also has to refrain from behavior that can actually impact the climate in such a manner that it will lead to human rights violations. And so a key question in this regard is, when does that actually happen? And there the court then resorts to international climate change politics, which of course said that we need to keep global warming between 2 degrees Celsius and preferably even below 1.5 degrees Celsius. So that is in a way the political, international political element there. And then there is this international panel on climate change, the IPCC, that is collecting all kinds of climate science and is describing different CO2 reduction paths that you can follow. And the IPCC, well, enumerates several paths. So if you reduce more now, you have to reduce less later and so on. But then again, international climate change politics has actually identified one of those as, at least according to the court, as the one that we should follow, which means that there is an obligation to reduce already 45% of global emissions by 2030. And then that is also the order that is given by the court to Shell. So the court says that Shell has to reduce that amount of emissions, and it bases that on the article for injunctions in the Dutch Civil Code, and that is Article 296 of Book 3. Now, what is really crucial to understand, and this relates very much to the last point that Phillip was just making, is that this order includes so-called scope 1, 2, and 3 emissions. Those different kinds of scopes, like that terminology comes from an international reporting scheme, a private reporting scheme. Not all oil companies use it, but Shell happens to use it, and many states as well. Scope 1 refers to the emissions that are coming from a company's own buildings and properties. Scope 2 are the emissions resulting from the production of energy used on site of a certain company. And scope 3, in Shell's case, refer to the emissions resulting from Shell's customers using its gasoline and other products. So if you drive your car with gasoline that you bought from Shell, then the emissions coming from your car are attributed to Shell. And that is very important to understand. By the way, the court does make a distinction here, because it says that Shell has an obligation of result for those scope 1 emissions, so it should definitely reduce them with 45%. But for scope 2 and 3, it has an obligation, a serious obligation of best efforts which is in a way also logical because Shell might have contracts with all kinds of other companies. So perhaps it cannot guarantee a result, but it should at least, take a lot of effort to reduce there as well. But why is this so important to understand? Because if you count indeed scope 1, 2, and 3 emissions, then indeed Shell is a very interesting, or any oil company is a very interesting actor to actually tackle through climate change litigation. And there is a very well-known report, which was also in a way, which also spurred a lot of climate litigation, which is called the Carbon Majors Report, made by Richard Heath. And that shows that about 100 companies worldwide are responsible for 70% of global emissions. But that is when counting scope 1, 2, and 3. So as soon as you count those scope 3, then litigation indeed might become an interesting instrument to tackle climate change, because you would only have to win about 100 climate cases to already tackle 70% of global emissions. Let's move to the next case.
All right. Thank you so much, Laura. The second case comes from France, and it is a fairly recent case. It was initiated by a group of NGOs. The name of one of them, Notre Affaire à Tout, is the name that has been used for the case. But there's, I think, about a dozen French environmental NGOs that initiated this case, and it's taken against the largest French oil company, Total, and it follows from a fairly new legislative initiative in France called the Duty of Care Law. That's how it's translated, the Loi de Vigilance in France. This new law, which I believe it's from 2017, if I'm not mistaken, was established to create an obligation for large French multinational companies, so large multinational companies that are either headquartered in France or operating in France, to do a kind of risk mapping of their entire supply chain, and to publicize that risk mapping with respect to the risks that their supply chain pose to human rights violations, to health protections, and to the environment. Now, it's important to note that this legislative action was not specifically developed for the oil and gas or the energy sector, but applies equally to all large multinational companies. There's a threshold of how many employees are employed by the company to determine whether or not this duty arises for them. But for all large multinational companies, this supply chain law applies. And the environmental NGOs in this case are piggybacking on the arguments brought in the previous cases against public authorities, which have established that, or at least beginning to establish that, climate change poses risks to fundamental rights and to human rights. And if we take that then for granted, a company that contributes significantly to global emissions each year, like Total SA, in mapping and developing a risk mitigation strategy for potential human rights violations in its supply chain, the environmental NGOs claim that they must also then account for the risks posed by climate change itself and their companies' emissions, their contribution to that climate change, that are posed to human rights protections and to the environment in a larger sense. So this is the basis of the litigation. It's a very new form of litigation because this law is so recent. It's one of the first cases that was filed in courts to litigate on the basis of these obligations in the Loi de Vigilance. So it's fairly uncertain how the French courts are going to react to claims like this. In addition to the violation of the duty of care law, the environmental NGOs are also arguing that Total SA has violated Article 1252 of the French Civil Code, which is a non-contractual duty to prevent ecological damage, that they have violated that in their contributions to climate change through the emissions of fossil fuels, emissions associated with fossil fuels in their supply chains. The alleged activities that Notre Affaire 2 are focusing in are twofold. The first is a failure in their risk mapping, that they have failed to acknowledge and account for risks to human rights and the environment that are posed by climate change, that they are aggravating in their contributions to global emissions each year. And second, that they are not only failing to identify and map those risks, but they're also then failing to develop sufficient mitigation strategies for the existing risks that already are posed by their activities as a company. And not just the activities of the company itself, that is to say, not just the sector 1 or 2 emissions of total SA, but the activities of their entire supply chain. So also companies that they directly and indirectly contract with, as well as the consumers that go on to use their products. The remedy then that they're seeking in this case is an injunctive order from the French courts to improve their duty of care plan, which is really at the heart of this duty of care law, that the company needs to put forward a plan in which they're appropriately mapping and developing mitigation strategies for the risks that their supply chain poses. So an injunctive order to correct or improve that duty of care plan, but also an injunctive order to immediately begin reducing emissions. And that corresponds with that second claim, the non-contractual duty to prevent ecological damages. Now, I'm not a specialist in French tort law, but my understanding from other scholars and commentators on this case is that the second part of this claim, the civil code aspect of the case, is much less likely to be successful than the duty of care law portion. So I think it is much more likely that the courts would be interested in issuing an injunctive order to correct the duty of care plan, well, an injunctive order to immediately begin reducing emissions, like we saw in the Milieu Defensie case, seems to be kind of beyond the boundaries of realistic aspirations as French litigators understand them at the current moment. But that's not to say that we haven't been surprised in the past as scholars who are interested in climate litigation, including, of course, here in the Netherlands with both the Urgenda case and the Milieu Defensie case that Laura just introduced. These were not by any means sure bet cases when they were first introduced to the courts. All right, so this is the second case, the Notre Affaire 2 case from France. Now we'll shift to a third case from Germany.
Yeah, this is a very interesting case indeed, against a German energy company called RWE AG. And it's the claimant in this case is Mr. Sao Julia. I never know how to pronounce his name exactly, so my sincere apologies for that. But you see his picture at the right there. And he works and lives in Peru. He works as a mountain guide and as a farmer. And he lives near a lake, Lake Palcococha. And he is very, well, there's a threat actually there, because this glacial lake may flood due to melting of a glacier. And of course, the melting of glaciers is one of the things that is caused by climate change. I think already at 2 degrees global warming, it is likely that all glaciers will eventually melt entirely. So he, well, obviously is afraid for that, and therefore he started this claim against RWE, which is reportedly Europe's single largest emitter. And in order to substantiate his claim, he uses the legal basis of neighbor nuisance in the German Civil Code in paragraph 1004. And this paragraph states that when ownership is interfered with, the owner may require the disturber to remove this interference, except where the owner is obliged to tolerate the interference. So, well, Mr. Julia and his wife, they own this house that would be severely affected should Lake Palcococha overflow. And he argues that such an event would be the result of climate change, which is allegedly then caused inter alia by the business practice of RWE. And what is very interesting is also the remedy sought here, because it is this time not an injunctive relief like in the other cases, but rather the award of damages. And then 0.47% of the amount needed to build protection measures. So he wants to build a dam to protect not only him, but actually also the whole village where he lives. And where does this percentage come from? Well, that is according to that carbon majors report that we already mentioned, the percentage of global emissions caused by RWE. So a proportional liability. And that is very interesting. Of course, how courts would deal with this, and perhaps not entirely surprising, in 2016, the District Court of Essen denied this claim because the court felt that there was no proof of causality. It found that it is very difficult to relate, on the one hand, a very specific event, namely a flood, that then needs to be attributed in the first place to climate change, but then in the second place also to this particular company in Germany, RWE. And it was also that court that said something that we said earlier when we discussed the challenges of establishing legal accountability for climate change, namely that we are all to some extent emitters of CO2. So it really, the point of causality was a problem there. So it was perhaps not surprising that on appeal, this issue of causality was really the issue. And well, the argumentation of Mr. UvA is that climate change, indeed, it's not a conditio sine qua non causation. So it's not if RWE would not cause those emissions that climate change would not occur. But there is, in fact, a linear relationship, because the more emissions there are, the worse, climate change will just get worse and worse. So there is, in a way, a very clear line of causation there. And that's, of course, also why UvA only asks for that small percentage of the damage. And something that is very interesting as well is that in 2017, the Regional Court of Hem, the court that then decided on appeal, reiterated the private law principle that harm should be compensated even if the harmful conduct itself is not forbidden. And that's, of course, a very important principle also in relationship to that earlier remark we made, that this oil and gas sector is so highly regulated. So whereas in public law that could perhaps be an excuse, in private law it is not, because even where harmful conduct is allowed, where the conduct is allowed, the harm might still be needed to be compensated. There was, however, not yet made a substantive decision by the Regional Court of Hem in 2017. It only allowed the proceedings to move to the evidentiary phase. So it basically said to both parties, okay, so in principle, we perhaps accept this argumentation about causality, but now you should prove that there is indeed an actual causal link. And this is, of course, a very long time ago. And from what I understood, there was an extra delay because the judges actually wanted to make an on-site inspection in Peru, and they haven't managed to do that yet, also due to the pandemic. So it's exciting what this case will bring.
Fantastic. And now we shift to then a fourth case, which is in many ways quite similar to the UvA case from Germany. This fourth case is known as the County of San Mateo versus Chevron. However, the name is slightly misleading after the County of San Mateo. So the county being a governance level between municipalities or cities on the one hand and the state on the other hand in the United States, kind of like something maybe similar to a province in some countries, but it's an intermediate governance level. The County of San Mateo, this is the county just south of San Francisco, where much of Silicon Valley is located in California. And the County of San Mateo, after filing this lawsuit against Chevron, was joined by a number of other counties in California, as well as some municipalities as well. So it's representing a group of public bodies of municipal and county level governments. And the case is not only against Chevron, but it's against about a dozen of the largest North American oil and gas companies, including companies like Conoco and ExxonMobil. Now, very similar, and the reason I said this was similar to the UvA case is that it relies on a series of common law torts called the public and private nuisance torts, which is essentially the common law equivalent to the neighbor nuisance rule of civilian countries, of using civilian code. The public nuisance tort is a similar claim in that someone is conducting either a lawful or unlawful activity, but that activity is associated with a harm to the enjoyment of property, of real estate, that is shared among an entire community, or like the vast majority of members in an entire community. That's the public nuisance tort. So in that case, these county governments and city governments are speaking on behalf of a large and representative body of private property owners within the county who are whose property is harmed in some way by the emissions and the contributions to global warming that Chevron and other oil and gas companies have contributed to. The private nuisance tort then shifts focus slightly and treats the county of San Mateo, the other counties and cities involved, as private property owners, of course, as small government bodies. They also are private property owners. They own different parcels of land within their counties and city boundaries. And here, these counties are claiming that, like under the public nuisance, their specific enjoyment of private property has been harmed by the actions of Chevron. In addition to those two torts, which are very similar to the tort or the principle used in the UvA case, they're also claiming a violation of tort of trespass. Here, you need to think of we tend to think of trespass in a criminal term very often, but it also has a corresponding tort law connotation. And here, the trespass, the unlawful entry onto private property, is essentially the rising sea levels, which, according to the county of San Mateo, they never gave permission to Chevron to contribute to local as well as global sea level risings, which are intruding upon the privately held land owned by the county of San Mateo. So in this sense, it's a very similar kind of case as the UvA case. Although we're not dealing with the kind of transnational aspect of UvA, the doctrine which is being applied is fairly similar. And likewise, the challenges that are going to be tested in the case are very similar, right? How do we correspond the specific emissions activities of Chevron and the other defendants with the specific harms experienced by the plaintiffs associated with climate change? Now, this is a photo on the screen right now taken by the county of San Mateo, which is just illustrating that the harm associated with rising sea levels and essentially storm surges, right? More violent seas that occur with more intense storms caused by climate change. That is very literally resulting in a loss of land as parts of the shoreline of the county of San Mateo, which has an enormous shoreline along both the Pacific Ocean and in the bay underneath San Francisco, is eroding away to the detriment of private and public property owners there. But in addition to those claims, they're also using two product liability torts. So the failure to warn tort and a design defect tort, essentially claiming that the oil and gas companies that are the defendants in the case knew or should have known, reasonably should have known, what the consequences of the consumption of their products would entail with respect to global warming and in particular sea level rises and intensified storms. And they both failed to warn that to their consumers, as well as essentially sold a product which had a design defect, right? That the consequences of climate change constitute a kind of defective product. Now, these are borrowing, well-known manufacturer liability concepts with respect to products, in trying to use them in the context of oil and gas products, right? Gasoline, petrol, diesel, things like that. So it's a very creative use of manufacturer liability that we see in this case, bound already with a fairly creative use of nuisance torts as well. Now, the remedies they're seeking in this case are both compensatory and punitive damages for the property damage or harm to property that has been experienced by the plaintiffs. In addition to that, they're asking for an injunction to abate the nuisance, which they don't say it directly in the notice that was filed, but the kind of logical conclusion would be that the injunction would require the oil and gas companies to radically reduce emissions. It would be the only way that the companies would be able to abate the nuisance if alternative solutions like geoengineering were not on the table. I suppose that could be a kind of counter argument raised by Chevron and the other oil and gas companies. The last remedy that I want to bring to your attention is also notable, and that's the equitable disgorgement of profits. So they're asking for the court to seize profits which were obtained by Chevron and the other defendants through the activities that constituted the public and private nuisance, the trespass, and the product liability actions. Now that would have a massive impact on the oil and gas industry, of course, if their profits were disgorged as a result of this lawsuit. And it shows, it juxtaposes quite nicely with the UvA case, where, the total amount of damages that is claimed in the UvA case is less than 20,000 euros. I think it's about 17,000 euros, if I remember correctly. Whereas in the county of San Mateo, there isn't a price line set in the notice of claim document, but we could easily imagine this case stretching into the billions of dollars, right? So in terms of financial impact, this litigation poses a huge threat to the industry directly, whereas the UvA case poses perhaps a very indirect and diffuse threat to the oil and gas sector. And part of the reason why the County of San Mateo and the co-applicants in this case can raise such large claims and try to achieve such large remedies is because they are going against such a large contingency of major emitters, and not just focusing on a single emitter like RWE in the previous case. So this case is still a long ways away from having any resolution. The two parties have been fighting for the last 4 years about whether the state courts in California or the federal courts should have jurisdiction over the decision. The dispute about jurisdiction reached the Supreme Court in this past year, which essentially overturned the reasoning, the initial reasoning offered for the jurisdiction to be given to the state courts, and suggests that it's pretty likely that the federal courts are going to have the jurisdiction to hear this case, which is not what the County of San Mateo was hoping for, but certainly does not mean that their case is lost hope at this point. So it'll be very interesting to see what happens with this case. Also, to kind of bring our our discussion here in full circle, what we see here is, and I haven't pointed out directly, what we see here are public authorities no longer being the defendant in cases like in the human rights cases that I introduced at the very beginning of our presentation, but here taking action themselves as litigants against the private sector. Now, it's not state governments, it's not federal or national governments, we're talking local level, municipal and county governments, but still public authorities acting in their role both as private property owners, but also representatives of public interests, taking cases against the private sector.
Yes, indeed. And this brings us to our concluding remarks. So I would perhaps like to make two concluding remarks here. And the first relates to legitimacy and the second to effectiveness of these cases. So what we have seen, as Philip also pointed out earlier, is that in cases against public authorities, there is this tendency to base the cases or relate them to human rights infringement. And that also is a legitimizing factor of judicial lawmaking on climate change, if you like, because if cases are brought before the court will decide rather than political institutions, and that makes these cases often controversial. But then when they are based on a human rights-based reasoning, human rights being the instrument to counterbalance majoritarian decision-making, these human rights have a legitimizing effect. Now, the interesting thing with regard to cases against private parties is, of course, that this whole issue of legitimacy, democracy, separation of powers is less at play there because, well, it's not a democratic majority, but rather a private actor. And in that regard, it's also, we think, very interesting to see that whereas two of the cases that we discussed today, namely the Shell case as well as the Total case, indeed do include human rights-based reasoning or related reasoning in the claim. Two of the cases actually do not, namely the UvA case and the San Mateo case. So it will be interesting to see, of course, how this will develop and whether human rights-based reasoning is indeed also in a way necessary in cases against private actors or not. Now, another point relates to effectiveness, and this is a point that is often raised by the defendants in these cases against oil companies, because and that is very closely related as well to the legitimacy. And because one of the arguments raised by the defendants in these cases is that one climate case will not solve the climate problem. And well, of course, we already mentioned these scope 1, 2, and 3 emissions, and the fact that if you would count scope 3 emissions as well, then you would need about 100 cases to cover 70% of the world's emissions. But of course, the oil companies always say that they are only responsible for scope 1 emissions. That's a recurring argument. So can indeed these cases contribute effectively to mitigating mitigating climate change or its effects? And in that regard, it's also very interesting to compare a bit the remedies sought in these cases, because we saw that there were some cases that were asking for injunctions that asked for actual emission reductions, whereas, for instance, the Total case also had this injunction formulated as an order to report and to map the risks that come with climate change litigation. And yet another two cases are asking for compensation of harm. The UvA case only of a very small percentage even of the harm, and the San Mateo case of a bit of a larger amount of money. And then, of course, very interestingly, the San Mateo case is also asking for punitive damages and to redistribute in a way the profits made by these large oil corporations. So I think it's fair to say, or we think that it's fair to say that each of these cases in and of themselves are only a drop in the ocean when you look at the global climate problem. But what they do as well, apart from establishing legal obligations for certain actors, is they help to build a narrative, and that's also what you see on the slide there, to build a narrative of private sector accountability for climate change. And that can have a way more widespread effect. So one case in point, I think, here is that after Royal Dutch Shell was ordered to reduce its emissions in the Netherlands, soon after another relatively large emitter within the Netherlands, namely the local part of Tata Steel, announced to move to more climate-friendly production mechanisms. So even if Tata Steel was not sued, or not yet, because I think Milieudefensie actually was thinking to do that as well, they already feel that indeed the private sector might also have this legal obligation, and that might in the end be the biggest strength, if you like, of these cases. That's all what I would like to say for now. Philip, do you have anything to add to this?
Yeah, perhaps I'd like to just add that in both the line of arguments premised more or less on human rights or fundamental rights violations, and in the line of arguments like we see in the latter two cases premised on nuisance torts. In both of these cases, they entail a narrative building process that taps into a well-established and well-accepted framework, normative framework of very kind of fundamental principles in law, right? The right to life, the right to property, nuisance. Nuisance torts are very historic torts that have a kind of well-defined and identified position, that is to say, I mean, historically premised on a neighbor or a property owner or economic operator nearby who is perhaps emitting toxic or noxious fumes, smoke, in some way that impairs the enjoyment of property rights as a private property owner. And it's taking these very familiar normative frameworks and bending them slightly or a lot, depending on your perspective, but beginning to put the burden on the defendants in these cases to say, explain to us, actually, to the court, how is it that global greenhouse gas emissions are different from the types of gases and emissions that were intended to be covered by a nuisance tort? What is it? Because the harm seems to be quite similar, at least of the same category. And so if you're going to tell us that this tort does not apply in the instance of carbon emissions, what is the difference between these different types of emissions activities? So I think that's something very interesting to hold on to, is this very innovative and creative use of fairly historic and well-established aspects of legal systems, right? And trying to make new use of these familiar terms. I think that's all I have for you today. I want to thank my colleague Laura for joining me.
Thank you very much.
And of course, thank our audience for their attention. And we hope that you enjoyed this and learned something about the kind of innovative edges of climate litigation today.
Exactly. And as we're both still working on this topic, I think we also welcome very much questions or comments in case you have them. So thanks a lot.
All right. Thank you, everybody, and have a nice day.